the Frisbee case. If you are from Colombia and you like Frisbee, this video is for you. My name is Derek Fehee. I'm a registered patent attorney and intellectual property attorney with the Plus IP firm. And this is going to be a short video on what's going to happen between the Colombia Frisbee chicken franchise and the Copycat that's in Europe. So you may have heard of this, but if you're from Colombia, you may have had Frisbee, which is a chicken restaurant, kind of like a KFC for all my non-Colombianos. And essentially, this brand Frisbee has been around for, a couple decades or so. And they sell chicken, like fried chicken. And Frisbee Colombia Frisbee actually filed to register their brand in Spain, several years ago. But they never went through with it and never got a registration. Come to find out that another brand and somebody else, another party, a second party, actually put up a website and is trying to open up a franchise that has a lot of content, especially on the website, that looks just like Frisbee. Now, what's interesting is that trademark rights typically only exist in the areas that you use them. So if you're not using trademark rights in Spain and you're from Colombia, then you may not actually have rights for the brand that you're using in Spain. So for example, Frisbee operates only in Colombia. The question then becomes, well, do they have rights for Frisbee in Spain? All right, that's one of the questions that is coming up. Well, I am not a European attorney, but I am going to give you my thoughts on this case. So first off, one of the things that the competitor or Copycat copied was actually the famous logo, the chicken logo. Frisbee has this really distinct chicken logo that you see everywhere. He has got it wearing a red coat and has got a chef hat on. It says F on there. And it's very distinct. You can see it in their franchise materials. That is protected with copyright protection. The artwork is protected with copyright protection. And even though the Frisbee in Colombia even though the Colombian Frisbee franchise did not register or did not actually register the brand in which is the brand name Frisbee in Spain, they still have copyright protection, which is essentially what the treaties that we have right now are more or less global. So when you create artwork, the person that creates your artwork owns the rights to it, and Frisbee Colombia probably owns the rights to that particular chicken artwork. So the person that uses it in that use it in Spain without the permission of Colombia Frisbee is not able to do that. So I think that the Colombian Frisbee can actually stop the Spanish Frisbee or the Spain Frisbee. So that's the first thing. The second thing is, again, I'm a U.S. attorney, but there are laws in the U.S. in particular that says that you can't have a false affiliation. If you're creating some sort of false affiliation with somebody else, there may be a cause of action. In the United States, we call it a false affiliation claim under the statute. It's a statute under the Lanham Act that says you can't create a false affiliation with somebody else. Now, even though there may not be registered trademark rights in Europe, there may be like a false affiliation or someone basically tricking you to think that there's somebody else. So just because the Frisbee in Colombia did not register the rights in Spain, I don't think that they're dead in the water. It is certainly going to be a lot more of a pain in the butt, which is why we always recommend clients, register their rights. But they do have causes of action, for example, copyright infringement or the equivalent thereof in Europe. They may also have some sort of false affiliation or deception claim or unfair competition claim or the equivalent thereof in Europe. And they may actually still have some sort of trademark claim or trade dress claim because they're actually copying the information, they're copying the content on the website. So that's just something to think about. Just because you're not using the brand, or just because you're not, you don't have a registered trademark rights, does not mean that a competitor can just copy everything that you're doing wholesale. I think it's going to ultimately, go to the favor or be resolved in favor of Frisbee. but it's going to be much more of a pain in the butt because they did not register what they should have when they had a chance to. But good luck, Frisbee Colombia. I am with you. Hope you enjoyed watching this video. I'm Derek Fehee, patent and IP attorney with the Plus IP firm. Thanks for watching.